everybody. Welcome to the LGBT Bar's podcast and webinar series, where we cover issues around promoting justice through the legal profession for the LGBTQ plus community in all its diversity. My name is Dru Levasseur, and I'm the Deputy Program Officer for the National LGBT Bar, and I lead Lavender Law 365, which is the only LGBTQ plus inclusion coaching and consulting program designed specifically to enable the implementation of best practice standards for LGBTQ plus equity across law firms, law schools, and companies. If you'd like to continue to hear content like this, be sure to keep an eye out for us on SoundCloud. And if you're watching this on our YouTube channel, hit the subscribe button to be notified when we release a new episode. Today, we're going to be talking to Professor Christopher Czerwonka. Professor Chiwanka is the legal director of the Strong Children Wellness Medical Legal Partnership, is a New York licensed attorney and special professor of law at the Maurice A. Deane School of Law at Hofstra University, where he presently teaches bioethics and the law, public health law, policy and ethics, and the ADA statutory interpretation, a course he developed for the law school, in the online LLM and MA program. He also lectures worldwide on disability law and anti-discrimination advocacy and practices in these areas, immigration law, public benefits, and general and special education law. He is an appointed member of the Adult Ethics Committee in the Division of Medical Ethics at the Northwell Health, one of the nation's largest healthcare systems. And he also holds an appointment as a research fellow at the Center for Policy Research at Rockefeller College of Public Affairs and Policy, SUNY Albany, where he researches and lectures on general public consciousness of constitutional rights and on issues of subordinated identity in the law. Wow. In 2014, the president of the New York State Bar Association appointed Professor Chiwanka to serve on the State Bar Committee on Disability Rights. In that capacity, he is one of the chief advisors to the bar on such matters. He also worked at the Transgender Legal Defense and Education Fund in New York, working on legal name change cases and on anti-discrimination litigation, mostly involving health insurance refusals to cover gender confirmation surgeries for trans clients. A nationally recognized authority on intersections between disability and LGBT law, he has consulted pro bono for Lambda Legal, which is where I had him come in and lecture, advising on test case litigation and leading a strategy seminar on this topic for all of Lambda's offices, and has been highlighted by the National LGBT Bar Association for his expertise and contributions to this subfield. Professor Chiwanka is committed to civic education for all young people. In that spirit, he was appointed in 2016 to the New York State Bar Committee on Law, Youth, and Citizenship and its mock trial committee, where he co-wrote that year's high school mock trial tournament problem, Robin Berkman versus County of Dover. Additionally, he lectures on the Constitution and other civic and historical topics to elementary school-age students. In his life away from law, he is an accomplished, though semi-retired, singer and devotes time to community organizations. Welcome, Professor Chiwanka.
Thank you very much. For a second there, I thought I was in the wrong room.
Well, I'm really excited today to have you here to speak mostly to our law student membership, especially about your experiences going through law school and entering the profession and becoming a law professor as a person with a disability. And I also consider you such a great friend and trans ally that I want to touch on some of the intersections between particularly trans rights and disability rights. So first, can I just ask you to share anything you'd like to with law students about your pathway into law school and beyond?
Sure. Excuse me. So I did 4 years of undergraduate studies at the State University of New York at Albany, where, as you mentioned, I currently have a faculty appointment at the Center for Policy Research. It was a great experience studying political science in New York State's capital. And then I went immediately into law school at Hofstra, where I ended up coming back to teach as a special professor, and really enjoyed my time there, and really found my interest in immigration law particularly there. I had a wonderful professor by the name of Maurice A, who is now a colleague and friend of mine, who taught the immigration law seminar with a guy by the name of Patrick Young, who's also a good friend of mine. And I had always sort of viewed immigration law through the lens of human rights. But I walked into the course thinking, that this is something that'll be nice to have in the back pocket while I do more domestically focused human rights work. But what I found in taking the course was that I had a real passion for it, and an unexpectedly zealous passion for it. I had always found it interesting, sort of in the abstract, dating back to my undergraduate courses in law and society, but it wasn't until I actually took the doctrinal course that I realized that this could be a satisfying path. And so I did some clinical work in immigration law, and now it's actually one of my primary areas of practice. More recently, it's been challenging for reasons that have been in the news, and part of my work in immigration has shifted over to policy advocacy as opposed to direct client representation. But it is one of the areas of law that I'm most passionate about, which is to say I'm passionate about all of them, but I have particular passions around anything having to do with civil rights. In terms of my experiences with disability law, the interest there is both professional and personal. For those out there who may have read the member spotlight that the LGBT Bar so kindly did a few months back, that I have cerebral palsy myself, and so in a very real sense, that area of law is very personal to me, and I started studying it even before college. Did an independent study with a disability law expert who is on the faculty at Albany, and continued to sort of nurture that passion through law school and beyond, with help from folks who were veterans of the field who had some stories to tell that sort of colored my view of the subfield beyond the stuff that I was reading in the case books and the journal articles. So that was sort of my educational pathway. If you'd like me to elaborate on any part of that, I can, if any of that wasn't clear.
That was great. Can you share some of I know that, because I know you personally as a friend, I know that you've experienced many barriers along the way to entering into the legal profession. And I think it would be helpful if you were willing to share any personal stories around the challenges that you faced and how you overcame them.
Sure. So one thing that I will say is that the number of lawyers with disabilities in the profession is very small. Particularly the number of lawyers with visible physical disabilities is even smaller. As a matter of fact, I could count on maybe both hands and maybe a few of my toes the number of people with physical disabilities who are lawyers I know. And so it's a very small group, and that means doing a lot of education with the agencies that I work with in terms of USCIS, representing clients, or the EEOC, although the EEOC is in the business of disability, so their folks have more training and experience with that, so that's a little easier. But also, walking into a court and appearing before a judge for the first time who may not understand, okay, I'm not going to stand up every time I make an objection because it's not something that I can comfortably do. But once you sort of have that conversation, most people are pretty good about it, and the few that aren't, I tend to remind them of their ethical obligations to treat me as a person with equal dignity at the law, and remind them that I would have no hesitation if the behavior continues about making a professional misconduct issue out of it. Fortunately, I have yet to have a situation where it has risen beyond the fact of the warning to whoever has, behaved inappropriately, if you want to put it that way. I've never actually had to make the complaint, but it can be pretty uncomfortable to stand in front of a judge and say, Judge, this is clear judicial misconduct, and if it continues, I'm going to make an issue of it.
Right.
But usually that does it. In terms of the LSAT, I will say the Law School Admission Council has come a long, long way from when I was applying to law school and when accommodations were a fight. So initially, I had not gotten all of the accommodations that I had had throughout my years of schooling, and I do believe that it negatively impacted my LSAT performance. However, I did get a score high enough to get into a very good law school, so I was happy about that. And I'm happy to say that after long periods of negotiation and things going on sort of behind the scenes, LSAC and groups representing the interests of people with disabilities came to an amicable agreement for a pathway forward. And I haven't heard of any problems there. So I would really applaud LSAC for realizing that there was room for improvement and taking steps to make that happen.
Well, it was in part thanks to you as a plaintiff in that kind of case to make sure that they corrected what they needed to do. And we were really glad to have Kelly Testy on in this podcast series to speak, but I'm really glad to hear from one of the plaintiffs in that case challenge.
Well, actually, can I just clarify? I was not one of the plaintiffs. I was actually asked by Hofstra whether I would be interested in co-writing an amicus brief. But by the time that was in process, and an amicable agreement was already reached. So I just want to be clear that I was not a formal plaintiff in the underlying litigation.
Well, thanks for your work on that. And it sounds like, the number of people you said with visible physical disabilities are so few that it sounds like you've had to kind of advocate for yourself often. Have you found that you a lot of mentors in the field, or how have you navigated mentorship?
So it's interesting. In terms of mentors with disabilities, I really haven't. The mentors that I've had are people in other areas of civil rights law. So, I don't mind going public and saying, I certainly count the person I'm talking to right now as one of my first, longest, and best mentors. But, it was also people like Noah Lewis, people like, professors like Loris Wren and Pat Young, who I mentioned, who, weren't, they were interested in me as a student and in the work that I was doing academically, but they were also interested in getting me to a place where sort of I how shall I say this? I was okay with the effects of my disability in the practice, and had some, strategies to manage them. Yeah, every once in a while, I get a situation where something happens and I have to sit down with an administrative agency and explain to them something that, frankly, I think they should already know. But usually when I call attention to those sorts of issues, agencies are pretty receptive, and where they're not, I do have the, you're potentially looking at a lawsuit here, card to play. But I tend, both as a disability lawyer representing others with disabilities and in my own personal life, a lawsuit is the last place I go, because I often find that a conversation that explains to an employer or a school or a government agency or a court that says, here's what you're doing, here's how it's negatively impacting my ability to do my job, or negatively impacting my client's ability to get an education or work or whatever it is, 99% of the time, that conversation, coupled with, and by the way, this is not, the manner in which one is accommodated may be negotiable, but the fact of accommodations is not. Right. Assuming that one is covered under the statute and it's not unduly burdensome, which is, that's a legal question that if you'd like to talk about how one would do that sort of analysis later, we can. But assuming that there are no undue burden or safety issues, accommodations are not negotiable. The nature of the accommodations are negotiable, but
Mhm.
accommodations themselves are not.
Right, right. And I'm imagining that there are law students with disabilities who are watching, and also law students who do not have disabilities but would like to know what kinds of things they can do as allies to kind of get ahead, so that you don't have to wait until something to happens, and then you have to go in and kind of explain, how the law works each time. So I know
Um,
that you work a lot with youth and invest in a lot of young people. You're teaching students, you invest a lot of time. What advice do you have for either groups of those students, what to do right now?
it sounds so cheesy and like fifth grade, but the best advice is be a friend and know what you don't know
Mm,
and commit yourself to finding out, um, and do the work. So for example, I'll give you an example in the LGBT context from personal experience. So I am a white heterosexual cisgender male, um, but I knew that I cared about trans issues and LGBT issues and racial justice issues, but I also knew that sort of in the abstract, I knew that I cared and I knew the law, but I didn't really know about the concerns of those populations from the inside. And so one of the things that I started doing was going to outlaw meetings, which was the law school's LGBT group, and spending time and learning and associating them. It helped that some members of Outlaw were already among my best friends anyway, even before I was part of the group, and they sort of gently encouraged me to, be a part of this for that reason. But that was a great learning tree to sit under. Um, Conversely, I remember walking off campus to a restaurant within walking distance of the campus with a friend of mine who was in the LGBT group, and it had just snowed um, on Long Island, and the curb cuts that are designed for a walker or a wheelchair, and I use a walker, the plows had plowed the snow in front of the curb cuts. And my friend turned to me and said, until this moment, I never had an appreciation for, the things that I don't even think about on a day-to-day basis, nor, frankly, this person I was talking to, grew up in a less diverse part of the country. And so she said, you're the first person with a physical disability that, to my knowledge, I have ever met. So I do not pretend to be an expert. And she said, she turned to me and sort of jokingly said, knowing you gives me so much more to be ticked off about. Because spending time with me, she saw how people treated me, and she saw the architectural barriers, and she saw sort of those things that we in our everyday lives don't think about that are real barriers to entry, both physical, mental, emotional, however you want to put it. I don't know if that answers your question, but I hope it at least starts.
Absolutely, it was beautiful, and I really appreciated another example of you showing up, particularly in LGBT spaces. Professor Chiwanka attended the Transgender Law Institute at this past year Lavender Law Conference, and had a wonderful amount to contribute to the group. And so I love the tip of getting outside your comfort zone of who you normally hang out with, especially LGBT folks, and to show up in other groups as well to really understand and get involved.
Yeah, you know what's interesting about that though? You mentioned stepping outside your comfort zone in the context of the LGBT group. I I actually didn't look at it that way. So I immediately felt like I fit in, even as a, heterosexual cisgender white guy, because here was a group of people who, yes, the differences we have are distinct in important and meaningful ways, but the fact of the matter is both of our communities have stood side by side historically in each other's civil rights fights, and I certainly appreciate the contributions of the LGBTQIA community to the disability rights movement. And I know, Drew, from speaking to you on these issues, that it also goes the other way.
Yes.
That the LGBTQIA community can appreciate the solidarity the disability community has shown with you historically. But what I'll say is, you know, being in a group, among a group of people who have been othered for things that they have not chosen and over which they have no control, was wonderful. So yeah, I'm not gay, but I certainly have some sense of you know, marginalization. Again, not in the same ways, and understanding that, you know, it's interesting. The friend that I was talking about earlier, we were having a conversation over lunch one day. She says to me, you know, how are you not bitter? Because, you know, she sees the way people treat me. And I'm like, well, if I end up becoming bitter, they win, right? So I refuse to do that. And, you know, she says to me, well, you know, you go through a lot more than I do as far as I'm concerned. I'm like, no, I don't. I don't. Because yes, physically, you may not have to think about the things that I think about. But if somebody discriminates against you, this was obviously well before Bostock. If somebody wants to fire you for being gay, unless you're in a state that has a human rights law that makes that illegal, there was no federal protection. If somebody wanted to discriminate against me for having a disability or not hire me because I had a disability, I had a federal law to run to.
Right.
And I've always recognized that that was one key advantage that I enjoy over the LGBTQIA community, which made me all the more determined to get that level of protection for that group. Because I'm of the view, you know, people say to me, nobody would blame you if you just sort of sat back and relaxed because you are a member of a marginalized group. And I said, no, what that means is it's doubly important that I speak up because I know the pain, because I don't want anyone else to suffer. And believe me, I'm not going to get into the nitty-gritty details because some of them still to this day are too emotionally difficult to talk about. But I know what it's like, okay? I do. Not in, you know, the sense of my sexuality, of course, but in the sense of being othered for ableist reasons. And once you've been there, you never want another human being to ever experience that, Drew. And that's why I fight so hard. That's why I refuse to rest.
Wow, very powerful. You're making me emotional here.
Sorry.
So, you know, I want to talk about you as a law professor. And first of all, you've brought that the LGBT work to your classroom. And
Yes.
one of the things I wanted to ask you to talk about is what one of your the ways that you call on students. Could you describe?
Oh, you mean what I call the name calling policy?
Yes.
So there is a. Do you? I believe it or not, I don't even remember the exact verbiage, even though it appears in like every syllabus because I copy and paste it into every syllabus. But Hofstra has a preferred name policy. Basically, you can go onto the Hofstra portal, and if the name you want to be called is a name other than your legal name as it appears in Hofstra's records, you can indicate that. However, I do recognize that certain people, for whatever reason, may not want to identify on an institutional level, and so my policy allows for that. Actually, if you give me a minute, what I can do is I can pull up on my phone the exact language so that your audience can hear it, if you wouldn't mind.
Sure, that'll be fine.
20 seconds.
Okay. And while you do that, I'm just gonna tell the audience in this intermission break that Lavender Law 365 is the program that I mentioned at the beginning, and that we are available to come in to do trainings at law schools. And one of the things that we cover is what Professor Chiwanka is talking about, and ways to call on students so that people are referred to by the appropriate name and also pronouns. And that has been a very hot topic for a lot of law schools, where they're trying to do the right thing and be inclusive of trans and non-binary students. So this was a great example, and I used Professor Czerwonka's sample policy as a model for other professors who are looking for language such as this.
Right. So I should preface what I'm about to say by saying that one of the reasons, among many, that I have this policy in my syllabus is that I do cold call students without having had an opportunity to ascertain what their pronouns are in advance. And so that's that. The second thing I'll say is that when you hear the word banner, that's just the name for our like official student record keeping system. So I didn't want to confuse anybody. Like, what about a banner? I didn't hear anything about a banner. So let me read you the policy as it appears in my syllabi. It says, in law school, it is customary for professors to refer to students by honorific and surname. For example, Mr. Jones, Mrs. Smith. Recognizing that such honorifics gender students without my having had an opportunity to personally ascertain their affirmed pronouns, I will call you by your first name only. You should be aware that Hofstra has a preferred name policy, which allows you to indicate the name you would like to appear on class rosters and grading sheets. However, I understand that for a variety of reasons, students may not wish to avail themselves of this option on an institutional level. Therefore, if your name of record in banner does not match your affirmed name, please send me an email letting me know, and I will happily call you by the correct name you indicate. Additionally, you should be aware that even under the preferred name policy, degrees, transcripts, and diplomas are issued in the student's legal name only. If you need assistance obtaining a legal name change, whether because you are a member of the transgender community or for any other reason, please speak to me after any class or send me an email and I can connect you to resources which may be available to serve you. By the way, for the avoidance of all doubt, you should refer to me in class as Professor Czerwonka. However, the moment you walk across the stage at graduation, please feel free to call me Chris.
Awesome. I love the ending. Well, thank you for sharing that. Another question I wanted to ask you about is, everybody's been struggling to adjust to online learning, and you have been doing this for a very long time. And when we talked about the, COVID and the impact on law students in particular, you had some really great words of wisdom about your experience. And I was wondering if you could maybe shed some light on your perspective.
Sure. So in a way, in terms of disabilities, COVID has been the great equalizer. It's a horrific equalizer, and I put that in its proper place, that thousands and thousands and thousands of people have died of this horrible disease, and I don't want to diminish the sadness and tragedy of that, for which my heart breaks. But in a sense, I think COVID is the great equalizer, in that events which previously would have been physically inaccessible, whether by location, time, or what have you, are all of a sudden accessible because everything's on Zoom now, right? So the events are coming to me. So, it has been, it's been good in a sense to have that level of access. And I think we'll begin to see it become sort of a new normal, even post-COVID, to do this sort of thing. Incidentally, I do think that it makes it harder for employers in the ADA context to make what's traditionally been known as an undue burden argument if, say, an employee with a disability is asking for a telework accommodation. Now, it's one thing if you work for Ford Motor Company on an assembly line, okay, and they need you physically there to, put, the tires together or whatever. I'm not an automotive worker, I don't know, but, but it's quite another if you are doing accounting or even law. It's going to be really hard for an employer to look at an employee with a disability with a straight face and say, this doesn't work with telework, because in point of fact, the whole world has been on telework for the last 7 months and you have your proof of concept. So I think the way that we practice ADA law going forward is going to change because of COVID. And if there can be said to be any silver lining to this horrific, horrific collective circumstance we find ourselves in, is that it may, in the long run, actually make it easier for people with disabilities to obtain and hold on to meaningful work that's fulfilling for them.
Excellent. Thank you. So we have just a few more minutes. I wanted to ask you, for students who'd like to reach out and get involved, would you like to share your contact information or any final words of advice or tips?
Sure. So you can always email me. And what's the best way to do this, Drew? Should I just spell out my email address, or do you want to give it to them, or
Yeah,
how would you
sure.
like?
If you could just spell it out, that'd be great.
Okay.
Thank you.
So my email is Christopher, which is CHRISTOPHER .E as in Edward, .C as in Charlie, Z as in zebra, ERWON as in newspaper, K as in king, A as in apple, at Hofstra, which is HOFSTRA.edu. You're also more than welcome to try my phone extension. That is area code 516-463-6652. Although I will say I generally do prefer email, and you'll generally get a response from me faster that way. It also gives me some time to sort of think through my response and give you the best resources that I can give you, and having done the research, send you a reply. Or if you're just a law student with a disability out there who's looking for a mentor that's, you know, somebody from the community, you're welcome to reach out to me. Or if you're looking to commit or recommit yourself to allyship with the disability community, I'm always happy to talk to you.
Thank you so much. Any other final words from you?
Only that, you know, depending on what stage of law school you're in, because I know that's the primary intended audience for this talk, you may have already found this, but particularly to those of you who are first year students. Now, in many law schools this year, the fall of 1L is a little bit different, again, because COVID. But as difficult as everybody said that it would be, and make no mistake, it is, and it should be, because we have an obligation to protect the public from unscrupulous would-be attorneys. However, as difficult as everyone says it is manageable, provided that you do what your professors are telling you to do and manage your time appropriately. And while my heart goes out to you if you are in a virtual learning setting for your first year of law school, I do think that this will give you a real sense of triumphing over adverse circumstances that will serve you well in terms of perseverance and resilience for the rest of your legal education. You know, you've chosen a very noble profession that serves, at least from where I sit, our highest calling is to serve the most vulnerable and weakest among us. And no matter what you want to do, whether you want to do corporate law and just do a bunch of pro bono, or whether you want to do what I've been doing and do public interest and serve people who can't otherwise afford to pay for outstanding legal services, you know, keep in mind your obligation to service, and make sure that you go to class every day knowing that, unlike college, where, you know, if you didn't necessarily do well in a class, you were really the only one who suffered because of it. Maybe your GPA would take a hit. Every day you go to class, keep in mind your obligation to your clients begins now. And so you have an obligation, and I understand that for the vast majority of law students, you're already doing this. But, you know, just as a reminder, you know, law school is professional school, which means We are in the service of others, which means everything you do down the line will affect others. So if there's ever a day where you feel like, you know, maybe the weather is nice enough where you don't feel like you have to go to one class, and believe me, I've met students that are like that. Okay, so it's not unheard of. You, at that point, fail in your obligation to your client to do your diligence to be the best lawyer that you can be. Now, obviously, if you're ill, or if there's a very good reason, obviously don't go to class. But, just because you don't feel like it is not a good reason. Do your reading, make sure you're prepared, ask questions, and don't dread the cold call. What I always say to students is a wrong answer to a cold call that nevertheless reflects careful preparation is actually more valuable to me than a correct answer, because with that wrong answer, I can then do some explaining, and it gives me a sense to see where the class as a whole is. So if you're prepared, don't be afraid to answer a cold call question incorrectly. It can be just as valuable a learning experience as if you had gotten the answer right, and oftentimes more so.
Powerful. You are a powerful and inspirational leader in the profession. And this is not easy to take all this time and share all this personal information. And I know that it's going to help a lot of people, Professor Czerwonka. So thank you so much for sharing your words of wisdom and for being with us today. And that's it for today's episode. A reminder that if you'd like to continue to hear content like this, be sure to keep an eye out for us on SoundCloud. And if you're watching this on YouTube, please hit subscribe so you'll be notified when we release a new episode. Thank you very much for joining us today. And thank you again, Professor Czerwonka.
You're very welcome, and thank you.